Commonwealth versus Van Dorsey, Jr.
Okay, Attorney Gaffney.
Morning, Your Honors. My name is Edward Gaffney, and I represent the defendant, Van Dorsey. We're here today on the appeal from the trial court's denial of Mr. Dorsey's motion for new trial and on his appeal from his conviction of first-degree murder. At the outset, I'd like to focus on the PTSD issue because I think that's the most significant of the trial court trial counsel's missteps, and also because it'll give me a chance to clarify for the court exactly what the issue is. Because contrary to some of the implications in the Commonwealth's brief, I'm not claiming that there was ineffective assistance of counsel because trial counsel did not shop around to find, quote unquote, somebody who was willing to say what Dr. Pittman said. My claim here is that counsel he didn't have to shop around for an expert, he had an expert. And it is that he failed to conduct an adequate investigation with that expert into PTSD. And that as a result of his inadequate investigation, he came to an unfortunately premature conclusion that PTSD was unavailable to him. And in that sense, he was ineffective because ultimately the defendant suffered two different types of prejudice. He was deprived of two substantial grounds of defense as a result of the failure to assess whether the defendant had PTSD, because he did. He had a severe case of PTSD.
I fully follow your argument. So he gets an expert. The expert evaluates your client, right?
Not really, Your Honor.
Doesn't do anything?
No, he does do something, but he doesn't evaluate.
Well, what does he do?
He asks the client, were you treated for PTSD? Have you ever been diagnosed with PTSD? That was the extent.
Well, that's the extent of what counsel reports in counsel's affidavit.
Correct.
There is one sentence in the record about what occurred with this expert.
Right. Well, that's one sentence about what occurred with the expert, and then the attorney goes on to explain that based on that information, he then concluded that PTSD was off the table. That's the critical mistake in my opinion, because, and I base this solely on not on Dr. Pittman's report, but this is on page 300 of the record appendix. That's where counsel's affidavit is. He explains the core of his defense was going to be based on the state of mind of the defendant at the time of the attack in this case. And so there really was only one question.
We have an affidavit from the first expert that's exactly the end of this, that he stopped there, because it sounds like per se malpractice by the expert to just stop there. So do we have any factual material to that effect, or this is just your conclusion that was it?
Well, my argument is based on trial counsel's affidavit, but not the expert's affidavit. Right. I don't have an affidavit from Dr. Jones, the individual who was.
Wouldn't that have been valuable to actually establish what you're saying? Well,
I suppose so, but I felt like trial counsel was the critical component to this. I mean, really, if the expert, because when the attorney hired the expert to look into this, I mean, the attorney dictates what he's asking the expert to do. He asked the expert to look into PTSD, and she reported back what she reported back. If trial counsel did,
just because you understand the factual background better than I do for sure, but I thought going into the request to Dr. Jones, trial counsel already had another expert who said this defendant has not been diagnosed with PTSD.
That's right, Your Honor.
So what counsel got back was something that counsel already knew.
Exactly. And my argument here is to speak to Justice Kafker's point. If counsel didn't get what he needed from the expert, he needed to send the expert back. I mean, the question was, did the defendant have PTSD at the time of the attack? That's the only question that needed to be answered in order for counsel to make an informed decision about whether PTSD was available to him.
Can I ask you for the best cases you have, because we've had cases where there's failures to investigate Ribeiro, et cetera.
Right.
Here we have not as fulsome of a review as you think is required, because there's an inquiry, have you ever been treated and diagnosed, which would give groundwork for later on. And I understand your argument to be, it doesn't have to be diagnosed. It can be.
Right.
So what's your best case as far as failure to track down this situation as opposed to a Ribeiro situation?
Well, actually, Your Honor, there is a case that, there's Epps, but Epps didn't actually.
Epps is a change in it's the shaken baby case.
Right, that's
a
the
change. The lawyer did all the lawyer could, and then the science changed in Epps.
Right.
Right. So the lawyer couldn't have done anything more than the lawyer did in Epps.
Right. The Epps doesn't have, it's not the holding.
That's apples and oranges to this case.
Right, that's right. It's not the holding in Epps, it's the explanation in Epps when it gets into the Kolenovich case, where actually that's what I thought the court was going to be interested in, speaking to Kolenovich, because I think that's probably the case that the Commonwealth would want to cite for its position. And why I believe Kolenovich is completely different is that the attorney in that case had abundant information, not only about the facts of the case. I mean, this was a man who had, the defendant had, years of alcoholism, and he had multiple witnesses were talking about how much he had drunk on the day of the crime. And he also had an expert who looked into that intoxication defense, who alerted him to the diagnosis of PTSD. And with all of that information, counsel made an informed decision that he would be better off going with the intoxication defense. Here, in my case, counsel had the evidence that the defendant had smoked cannabis and PCP, had information, as Your Honor said, that there had been no official diagnosis of any severe. There was information about PTSD, and as a result of that, counsel then decided to inquire of PTSD. In other words, this decision he made was not on the basis of a complete investigation. He didn't get what he needed. He knew he hadn't come to any conclusions. He was in the middle of doing the investigation and abruptly and prematurely ended the investigation into PTSD. And so he was deprived of a wealth of scientific evidence that would have been presented to the jury by an expert that would have not just contradicted the Commonwealth's theory of the case, it would have supported the defendant's theory of the case and corroborated the defendant's otherwise entirely uncorroborated testimony, unnecessarily and uncorroborated testimony.
I suppose this would be stronger, though, if the attorney had said, Dr. Jones then didn't tell me one way or the other if my client had PTSD. There's a gap in the affidavit. The affidavit says, Dr. Jones told me no diagnosis, which the attorney already knew. And then it says, I concluded that PTSD would not be a good defense.
Right. I mean, that's...
There is the gap there, though, in between, great. But what did Jones say for that conclusion, right? How did...
Well,
it would be better if counsel had said, and Jones told me further that, that diagnosis was not available, right? Like that the client didn't have PTSD. And therefore, I concluded.
Well, I acknowledge that, Your Honor, but
Isn't that a gap and a problem for the defendant trying to make an ineffective assistance of counsel claim?
Well, counsel said, he reported what he reported. He reported to me that this is what happened. And so...
Right, but that gap speaks volumes.
I actually disagree, Your Honor. I mean, what we have here is counsel's decision based on what he reported he learned,
Based on having consulted Dr. Jones,
right?
that PTSD was just not an available defense. We don't know what Dr. Jones said. We know one thing Dr. Jones says, but we don't know what else Dr. Jones might have said.
And don't we have to take this in context of what was actually presented at trial? It wasn't like there wasn't the mental health defense. Dr. Fife testified, correct?
There wasn't a mental health defense. I mean, the defense here was that the defendant was intoxicated with PCP, and
It was a diminished capacity defense.
in that sense. I mean, essentially what the closing argument was fairly amorphous, but essentially what counsel was doing was arguing that this was excessive self-defense. The defendant shouldn't be convicted of murder. He should be convicted of manslaughter because he was responsible for this, but he was acting in excessive self-defense. He came upon the victim with a knife in her hand, he panicked, and he killed her in excessive self-defense. Why I believe that the defendant was so severely prejudiced in this case was because as a result of not having this PTSD defense, he was not able to argue not only that PTSD establishes, a contradictory set of facts to the...
I'm still troubled by your response to Justice Wentland, though. So he speaks to this expert about PTSD. The experts aren't consulted on just record keeping. I mean, don't we have to assume we can't just assume your version of events because it just doesn't make any sense that an expert would be consulted about whether someone has PTSD. The expert's going to understand that the issue is whether he had PTSD at the time of the attack. So I don't know why we credit your version of this based on gaps.
Well, counsel's affidavit was based on...
Counsel's hiring a PTSD expert. Counsel, the obvious issue is whether he has PTSD at the time of the attack. And it's not whether, we're not consulting a records keeper, we're consulting a doctor, right? I just don't see why we draw your inference from this.
Well,
and is there a case that draws any remotely like that inference?
well, okay, I don't have a case with respect to that point, Your Honor, but I would point to paragraph 3 of the affidavit in connection with that strategy, the strategy that he just described, that, this was going to be about the mental health status of the defendant at the time of the stabbing. I arranged for a mental health professional, Dr. Tammy Jones, to interview Mr. Dorsey. I specifically requested that Tammy inquire of Mr. Dorsey regarding his treatment for PTSD and any related topics.
What about related topics?
Well, do you have PTSD? Well, I was never diagnosed with it.
So, but he could have asked his client that. He's hiring an expert to dig into whether he has PTSD. Or isn't that, I mean, it just seems illogical to me.
But then in the next paragraph, Your Honor, he says, after the meeting, the conclusion had been that Mr. Dorsey had never been officially diagnosed or treated for PTSD. I then concluded that I would not be able to use PTSD in support of my defense. I mean, he says it. I can't, he says this is the conclusion, and that's what, based on that conclusion, I drew my conclusion. Well, I understand
meaning he's got it's a hard defense to make when there's never been a diagnosis before, and you've just consulted an expert, and again, that gap, which we have to deal with, and the expert says, oh, I find he has PTSD. So I don't know, but you've made the point. But
well, and I would point out that that Dr. Pittman, in his report, he talks about the fact that there were other mental health professionals who talked to the defendant, and he took issue with the fact that none of them had assessed whether the defendant had PTSD at the time of the offense. So I'm not sure it's just an automatic consequence of investigating a defendant that you determine, you make a specific inquiry about whether he had PTSD or not. There was abundant reason for for trial counsel to ask that specific question. But what he said in his affidavit, I think it's pretty straightforward. I'm looking at paragraph 4.
Can I switch you to the adjutant issue, unless my colleagues have more questions on this one? So the adjutant issue.
Oh, yes.
The victims never used a knife. She's gotten into some, pushing and shoving and fighting with people she suspects are having relations with her boyfriend, the defendant. But do we really jump to, we really conclude it's error here or ineffective assistance not to push this so hard? Explain to me the logic of that, because he's going to stand up and argue she's never used a knife on anybody. She's never, gotten that violent, the victim, right?
Well, right. I would emphasize that the
fact that
adjutant.
she got pushing and shoving with an old competitor, is that really going to get us into adjutant issues here?
Well, it's not just pushing and shoving. It's slapping and scratching and hitting and punching. There's more to it than that, but there's no weapon.
Right.
I'll acknowledge that. There's no weapon. But that's not what adjutant says. Adjutant says, if there's a history of violence, if there's examples of violence, then
So balancing, the judge has got to make a decision.
That's right, Your Honor. And I brought up adjutant, I brought up the PCP issue, and I also brought up the defensive wound issue, all in support of the fact that this trial, the jury ended up with a very, very incomplete factual picture of what was going on here. The defendant testified. I'm sorry.
The basis of the adjutant evidence were the affidavits of the friends of the defendant?
Friends of the defendant and the defendant himself.
Right.
Right. And trial counsel said, I looked for adjutant evidence in the record, in the victim's criminal record. And my argument here is, why are you limiting yourselves to do that? That's not adjutant.
Maybe it goes to the prejudicial part of it or the substantial risk part of it, in ineffective assistance in a murder case. But shouldn't we consider whether or not these incidents were reported to the police, investigated, versus it's the defendant's buddies who are going to testify?
Well, it wouldn't necessarily. We don't know who would have testified. We have an ex-girlfriend, we have a friend, but she was also a friend of the victim, and we have a prior boyfriend.
Wouldn't it carry more weight, of course, if it was reported to the police and it was investigated?
Unquestionably, Your Honor. And it would have carried more weight if there
And we
was a
should
weapon.
consider that when we look at the amount of prejudice. to the defendant.
Exactly. This is all part of the picture here, an unfortunate picture where I think the trial counsel basically took the attitude, well, he's taking the stand, he's telling his story, that's all that's necessary. To the point, by the way, there's a case, I think it was you, Justice Gaziano, that asked for the best case. I think it's probably this case named Farley, where there was oh, I see I'm running out of time, I'll try to be fast.
Cited in your brief, we'll get it.
Yes, I cited in my brief. The victim the defendant, there was a lot of circumstantial evidence against the defendant, but there was evidence at the scene that a third-party culprit could have done it. And so the defendant testified, and basically defense counsel just left it there. Well, there's semen here. This could have been a man that did it. And what she said was true. And rather than dig in and get evidence, so the defense counsel's like, she had PCP in her system. Well, why didn't you put in evidence that was available to you that she had PCP in her system and just rely on an uncorroborated defendant? And he was, obviously his credibility was attacked, and it didn't have to be that way. That's my point here. Trial counsel left it when in a state that didn't have to be this way. especially because of that PTSD, especially because evidence of premeditation was so thin here. I mean, there's overwhelming evidence that the defendant killed the victim. That is not at issue. But the evidence of premeditation was that the knife had been taken from the kitchen and used in the living room. That's it. Inexplicable, no motive, this just happened.
Well, how many times was the victim stabbed?
6. And what the failure of trial counsel.
Hold on 1 second.
Trial counsel's
I have
failure.
a 92-year-old mother who, even when it says do not disturb, keeps pushing it, so I apologize.
My 94-year-old mother-in-law has already texted me. Lucky. Anyway, with respect to the premeditation issue, which I think is my strongest issue, because it is, I believe, the Commonwealth's weakest part of their case. If defendant had the PTSD evidence available to him, that would have been a profoundly significant part of this case. He would have had a strong argument that he wasn't guilty of first-degree murder. At worst, he was guilty of second-degree murder, because even if the Commonwealth's argument that they had a strong case that this was not excessive self-defense, even if the jury accepted that, the defendant still should have had the argument, I have a body of scientific evidence testified to by an expert that this wasn't premeditated, this was an impulsive, emotionally driven overreaction. And all it would have been necessary is for one juror to change their mind, because they needed a unanimous decision on premeditation. One juror changed their mind. This is a murder 2 conviction. The defendant didn't get to make that argument, and I think that is the most significant and most powerful of his arguments with respect to prejudice in this case.
Okay, thank you.
Thank you.
Attorney Shepard.
Thank you. May it please the court, David Shepard Brick on behalf of the Commonwealth.
Can I ask you what we should do about the attorney's affidavit? I mean, isn't it just per se an effective assistance to decide that there is no PTSD defense?
I think because the affidavit is insufficient, I think the defendant just doesn't meet his burden. I think especially not having an affidavit from Dr. Jones explaining what she actually did. Counsel's affidavit is a bit cryptic when he's talking about it. And the inference I suggest the court should draw is that a further discussion would not have aided the defendant. The defendant had been evaluated by at least 2 experts prior, one by the Commonwealth, one hired by a previous defense attorney. That expert, the defendant's previous expert, had said that he might meet the diagnostic criteria for PTSD, but he didn't find that PTSD would have impacted the crime at all. His explanation was that the defendant was so high on PCP that he didn't know what he was doing. And that was Dr. Joss. And so trial counsel had that. He didn't end up using Dr. Joss. He actually ended up using the Commonwealth's expert to put forward the same sort of defense.
I'm sorry, can I ask you about that? Is there anything in the record? I didn't see anything that bears on that point. Like, is it clear that Dr. Joss was unavailable? Because Dr. Joss's report is it doesn't get into the PTSD, but it's very strong for the defendant in saying that he, for a mental impairment defense based on PCP in a way that Dr. Fife was not, obviously, and really clearly was not going to be.
It's not in the record. There was a bit of a scheduling issue, although he could have come in, and trial counsel, for whatever reason, because we were potentially going to wait a day or 2 for Dr. Joss to become available. Is my memory of it.
Your answer is that there's nothing in the record.
There's nothing in the record.
Thank you.
But I think coming from the Commonwealth's expert, who is clearly not in support of the defendant's theory, and getting all of that information from her, I think is much stronger, because you have a doctor with no financial interest, no bias towards the defendant. She was our expert. There's a discussion in the record that if the defendant didn't call Dr. Fife, that the Commonwealth was going to call her. So he gets to sort of preempt the Commonwealth using the Commonwealth's expert.
No, the Commonwealth could have called Dr. Fife regardless. He doesn't get to preempt the Commonwealth. And the Commonwealth chose not to call Dr. Fife even.
Well, right. It's one of those that the Commonwealth wasn't going to call Dr. Fife until the defendant sort of put that defense in play, because it wasn't really in play until he testified. So yes, of course, the Commonwealth could have called Dr. Fife in its case in chief and considered doing so, but decided not to. And then the defendant decided to use her to his advantage. But again, I think the lack of an explanation, if we're under a substantial likelihood standard, it's the defendant's burden. It's the defendant's burden to show that better work would have accomplished something. We don't know what Dr. Jones told trial counsel. I have to assume that it was more than he's never been diagnosed with PTSD, because he already knew that. He already knew that PTSD was a potential based on what Dr. Joss had said. And so he asked her, he hired an expert to have a 2-minute conversation with the defendant. That doesn't seem very likely. It seems like that he was evaluated and that she determined that based on her evaluation, he determined PTSD was not available as a defense. But again, any questions that the court has fall to the defendant, that if he didn't meet his burden of establishing that, then there's no substantial likelihood of a miscarriage of justice. In terms of the adjutant evidence, the victim didn't have any convictions, and there were. I provided the court below, and it's in the Commonwealth's Appended Appendix, her criminal record. She has no convictions. She has no charges for violent offenses. There's nothing there. You have two people with serious credibility issues, a convicted child rapist and the mother of the defendant's child. So, and these are people who sat on this information until after trial.
Is that right? I thought the whole point that the defendant is raising is that they were just not asked.
So the only evidence that trial counsel knew about these people was from the defendant's affidavit. Trial counsel does not corroborate that he was informed about these witnesses. And he would really have no reason to investigate these witnesses.
Why not in a first aggressor case?
Because he looked where there would be, he looked at the victim's criminal record, which would give him
some evidence.
Well, it would give him credible evidence, because there'd be police reports, there'd be witness statements. You don't have, even with these two individuals, you don't have any independent witnesses verifying that these happened. One of them was allegedly a fight at a club. There's no bouncer, there's no people at the club, there's no video surveillance, police were never called. So we have someone with a serious credibility problem who is suggesting that this event happened, and there's nothing to corroborate it. So I don't know that there's any reason that, and again, the fact that counsel didn't say, I asked him about it, or the fact that or he didn't tell me, is again a deficiency in the defendant's showing that he doesn't have affirmative, and the fact that he's an available source and he didn't, of information, he provided an affidavit And he didn't say that the defendant provided me with these witnesses and I decided not to track them down. He doesn't say anything about it. And the court can and should draw the negative inference that it's because the defendant never told him. That an answer, all of these absences in trial counsel affidavit suggest that if he had included the information, it wouldn't have been good for the defendant.
When we look at the totality of the claims of ineffective assistance, one of the issues is the defensive wound, or what could be considered a defensive wound. Mm-hmm. At trial, we have a wound, and it's the classic, Commonwealth argues, the hand slipped from the slippery knife and
right.
caused a wound himself, right? But now we have expert testimony proffered that says that, in fact, is a defensive wound.
Well, consistent with the defensive.
Well, consistent with the defensive wound. It would have been admissible, of course, right?
Yes.
How is the defendant not prejudiced by that?
Because of the overwhelming evidence of his guilt, the victim was stabbed on the right side of the neck. There are cast-off blood stains on the inside of the door, and then right outside of the door on the right side of the hallway, suggesting that he was stabbing her in the neck and in the hand. She was stabbed in the right hand many times, which suggests, again, the medical examiner said were consistent with defensive wounds. It suggests that he was stabbing her while she was trying to flee the apartment.
Well, it's undisputed, and he didn't dispute that he did, in fact, stab her to death. The question was, who was the first aggressor? So that's the entire case, is who is the first aggressor.
Well,
can you go back to answering Justice Gaziano's questions? You said it's overwhelming. Why is the evidence on who was the first aggressor overwhelming?
Again, I think it's not just, the court can look to the behavior of the defendant, not just during the crime, but immediately after the crime, in terms of determining whether or not there was deliberate premeditation. And I would suggest the fact that he goes downstairs, according to circumstantial evidence, because we believe that she made that telephone call from the base of the stairs based on, she says, "I love you all," and then the line goes silent. There's no phone there. Her phone is found back up in the couch underneath the defendant, which suggests that he went down there and took her phone so she couldn't call for help. When the victim's family comes to drop off the kids and comes to the door, they see that Shaterika sees that the victim is basically lying in front of the door, blocking it. She sees that she tries to grab her hand slips because she's covered in blood. She calls up to the defendant. He comes down the stairs. She says to him, "What did you do?" He says nothing, but he closes and locks the door. And then he goes upstairs and he's looking out the window while the police are preparing to enter, because that's what the paramedic testified to. That he keeps looking out the window. He peeks out the window, and then he goes away, and then he peeks out the window, and he goes away. But then, when the police come in, he's face down on the couch, and he's not listening to their commands, and they have to scream at him to get him on the floor, and then he follows the commands, but then he has to. Then, as soon as they try to handcuff him, he's fighting with them. So it shows someone who's really trying to pretend that something is going on that isn't. And that was the Commonwealth's theory, was that all of this, the PCP, the alleged seizure that he had that was never diagnosed. He went to the hospital, they didn't find anything wrong with him. That all of this, and even the defendant's expert, his post-trial expert, says that the defendant malingers. He ascribes this creative reason for why he exaggerates his symptoms, but every doctor who has examined him has said that he malingers, that he exaggerates his symptoms, and that he makes it look worse than it is. And I think that shows that essentially the attempted cover-up, if you will, shows deliberate premeditation. And not just, and I think the location of the knife is significant because it was in the kitchen, and the box of knives was left on top of plates in the sink. So that's not where you store a box of knives. So
I think it's very clear from the evidence that someone determined to go into the kitchen and get the knife and hastily right before this crime happened. But the defendant's theory was that it was the victim who was mad because he was on the phone. And, there was someone who happened to be having a phone call with her, hearing him in the background having some sort of upset conversation. So the whole question was who went to the kitchen and hastily got the knife and put it.
Right. But what he said is that she came at him with a knife. They struggled for the knife. He got the knife, and then he just stabbed her. If that were in fact true, then why is she being stabbed while she's fleeing the apartment? And that's what the forensic evidence showed. So
was the neck wound the only sort of the most fatal wound, with like the major wound? I know she had a bunch of defensive wounds, but
she had a cut, a slight abrasion on her on her left arm. She had a stab wound to the top of the skull, which the directionality on that would suggest maybe they were facing each other, but that's again hard to say. No one testified to that, but it was, if he was stabbing her with her right hand, I believe it was down and to her right, if I'm remembering the testimony correctly. But she had bruises and scrapes on her face. She had bruises and scrapes and abrasions on her legs, which again could have potentially been from falling down the stairs. But there is certainly evidence of a struggle. But again, given the cast-off spatter stains, both inside the door and then outside the door, are incredibly strong evidence that she was attempting to flee the apartment when the fatal wound was delivered.
Can I ask, I haven't read this whole transcript yet, and I've got to do that, but is there a coherent defense here? Because appellate counsel has presented, obviously, sort of a coherent way the case should have been tried. We should have had PTSD evidence. We should have had the fact that he's been stabbed previously and he freaks out. I'm just trying to, was there a consistent diminished capacity? What are we seeing here? We read this entire transcript. Is this a tactical decision to go one way here? We can.
I think it is. I mean, so you'll see when you read it, the defense from the beginning is, I'm not going to ask you to not find him guilty. I'm going to ask you to not find him guilty of first-degree murder. It's consistent throughout that he is trying to elicit testimony, he elicits testimony to support his combined theory, which was the victim came at the defendant and the defendant was so high on PCP that he didn't know what was going on and he just grabbed the knife and he stabbed her. And I think that was his theory from the beginning. He elicited testimony from the paramedic that the defendant had scratches and cuts on his arm. And he used that in closing to say, look, that supports his claim that she came at him with a knife. And then he just overreacted, took it, and acted with excessive force in self-defense because of all the PCP that he had taken. And he used Dr. Fife to explain that PCP increases aggressiveness, it lowers inhibitions. It was a two-pronged defense, but I think it was a coherent defense in a case that there wasn't really a coherent defense in.
And lastly, from my perspective, so this is one of these strange, weird outbursts. Why is this not a second-degree murder? Why shouldn't we lower the verdict to second degree here? So give me the best arguments on that. Also, was extreme atrocity and cruelty presented
It was presented.
and rejected by the jury?
That's correct.
Okay.
There were 6 stab wounds. There were, which I think, again, I think the reason that that second degree, and again, I would go with, it's not one of those cases where, you have, two people meet, they have a fight, and then someone just pulls a gun and shoots. It's not one of those. This is a violent struggle, and then as she tries to flee, that's when he kills her. So I would suggest that this is not one of those types of situations. Like, he had a choice to just let her go, and he didn't. And he made sure that she was dead, because he went down and checked on her and took her cell phone so she couldn't call for help. So I would suggest that that shows that this is not one of those cases where it's just one of those freak things that happens, that this was, for whatever reason, deliberately premeditated. I see my time is almost up. If there are no further questions, I'll rest on my brief.